Hello, Namaste. This is Aparna Bhat and welcome to my YouTube channel Abhijna Legal Maps. So, this is a YouTube channel dedicated for law students, law aspirants, judicial aspirants and those who are appearing for CLAT or APP exams or any kind of competitive exams related to law. So, today I am conducting a session regarding section 16 of Specific Relief Act. So, this is a part of 48-day challenge series. So, this is the day 2 challenge where I had given a challenge of reading section 16 of Specific Relief Act of 1963. So, whenever I read a particular act, so how should we read the act? First of all, we can see the section here. So, the section contains different subsections and explanations and everything. So, it is not just sufficient to just glance over them, but we have to thoroughly understand them properly. So, section 16 is one of such important section because 2018 was a major change. It brought a major amendment in Specific Relief Act of 1963. So, earlier the relief of specific performance of a contract was discretionary. It was entirely upon the discretion of the court. But later, after 2018, this was made mandatory. The granting of specific relief, specific performance of a contract was made mandatory as per section 10, but it is subject to certain sections like section 10, section 14 and section 16. So, when that is the case, section 16 comes under such restriction, one of such restrictions. So, what does this section 16 say? Suppose there is a contract. What do you mean by specific performance? First of all, we have different types of specific reliefs. Okay? We have about 6 to 7 specific reliefs under Specific Relief Act of 1963. One of such reliefs is specific performance. So, general reliefs, we can give the examples of damages or compensation or etc. In case of general reliefs, we ask for damages, we ask for compensation. But when in the case of specific reliefs, we ask for the relief of possession, the relief of declaration, the relief of injunction. So, the injunction is in the nature of a preventive relief, or other examples of specific relief are cancellation of the instruments, rectification of the instruments, rescission of the contracts and also the specific performance of a contract. So, specific performance is one of the kind of the specific relief. So, when specific performance, a person is asking for a specific performance. So, what is happening actually? A is entering into a contract with B. The terms of the contract suggest that A on lending rupees 10,000 rupees, B will be selling 1 acre of land. So, these are the terms of the contract. So, the consideration amount is rupees 10,000. For the consideration of 10,000 rupees, B is selling his 1 acre of land. So, A is bound to give 10,000 rupees and B is bound to sell 1 acre of land. If anyone fails to perform this, if A fails to give 10,000 rupees or B fails to sell 1 acre of land in future on the agreed date, and time, then it amounts to the breach of contract. So, one of the party gets the right to ask for or seek for the specific performance of such contract. Okay. So, when this is the case, A has to file a specific performance of a contract. But as we have already seen, section 10 is a kind of a section where it says specific performance, the grant of the relief of specific performance of contract is discretionary, which was earlier, but now it has been made mandatory. It is subject to section 10, section 14 and section 16. So, what is this section 16 says? It says that certain persons are barred. So, it speaks regarding the personal bars to relief. First of all, they cannot file a specific performance of a contract. Even if they file, specific performance cannot be enforced in favor of them. That is the meaning of section 16. So, who are the persons against whom specific performance cannot be enforced. So, here we can see there are 3 terms A, B, C, 3 subsections or 3 clauses where an explanation is given to section 16C. So, when this is the structure of the section, if we understand them by way of a chart method. So, this is Abhijna Legal Maps is all about delivering the law lectures by method of this charts or flow charts or simplifying the legal education. It is all about that. So, if you haven't subscribed this YouTube channel yet, do subscribe and also share it among your friends. We also have a Kannada YouTube channel, that is Abhijna Law Series, which is related to Karnataka Judiciary and Karnataka law students, but this Abhijna Legal Maps, which will be in English, and this is beneficial for the students all over India who are seeking legal education and who want to be the judiciary aspirants or who want to become judges or any exams they want to write regarding competitive exams. So, let us come to our section 16. So, section 16 we see there are 3 categories. The first is section 16A. What does it say? These persons are again they are barred from filing specific performance, or in favor of them specific performance cannot be granted. So, section 16A says that one who has obtained substituted performance under section 20, in favor of him specific performance cannot be granted. So, substituted performance is one of the method which is a relief which is obtained in alternative to specific performance. This is a new concept introduced after 2018 amendment. So, this has been introduced under section 20, substituted performance. Okay. So, whoever has obtained substituted performance, such person cannot again obtain a specific performance. That is one restriction here as per section 16A. Section 16B says that, so the logic is like this: if a person is at fault, if he cannot perform a term of the contract, maybe genuinely or fraudulently, so he cannot ask for the specific performance, he cannot seek specific performance. So, who are those persons? So, we can say 4 categories here. The first person is one who has become incapable of performing. So, incapacity may arise due to some accident or some death, or maybe due to insanity or ill health. It could be for various reasons. Okay. So, incapable of performing, that is the first category. The second one is if the person violates some essential term of the contract. If he is violating any term of the contract, then that is a personal bar to a relief, or he is acting fraudulently in relation to a contract. Even then he cannot seek specific performance. And also the last one is if he is willfully at variance, willfully he is at variance with the terms of the contract, he is at subversion with the terms of the contract, even then what is happening? There is a personal bar to relief. Okay. So, this we can find under section 16B. And the third category is very important, that is section 16C. So, this is what we always find in most of the issues of specific performance suits, that is whether the plaintiff is always ready and willing to perform as part of the contract. So, this is a common issue where we find in most of the judgments, in most of the issues. So, what does it say? So, suppose a plaintiff is there, he wants to seek specific performance, then he should have either performed his part of the contract or he should be ready and willing to perform his part of the contract. If he fails in that, if he has neither performed or if he has neither willing nor he was ready to perform his part of the contract, even then he cannot seek specific performance, or specific performance cannot be enforced in favor of him. Okay. So, this is a very important concept, and this section 16C has 2 more explanations. So, it specifically says that suppose in a suit there arises an issue where there is regarding a payment of a money, issue is with respect to the payment of a particular money. The plaintiff need not actually deliver money, or the plaintiff need not actually deposit the money into the court to prove his readiness and willingness. Okay? Even if he shows his readiness and willingness, it is sufficient. So, they say that as per section 16C, explanation to section 16C, it is said that in order to show that a person has he was not at default under section 16C, if it is the case of the payment of money, it is not a criteria that he should have actually delivered or he should have actually deposited the money into the court. It is sufficient that he was ready to deliver, he was willing to deliver, it is sufficient. So, that is the explanation, the gist of this explanation. So, when he is ready and willingness to perform, but the defendant is preventing him or the defendant has waived his part of the contract, then he has to prove. Otherwise, if he fails to prove that also, then the plaintiff is not entitled to the specific performance. Another explanation to section 16 says that the readiness and willingness should be proved. Okay? So, without proving this, plaintiff is not entitled to specific performance. So, the proof is very, very necessary. Earlier, before 2018 Amendment Act, it was necessary to aver and prove. The word aver was there. Aver and prove means it was supposed to be, the readiness and willingness was supposed to be mentioned in the plaint, and then in proof also it was supposed to be proved. But later, due to lack of these kind of conditions being met and many cases being failing due to the non-fulfillment of this aver, they removed this category. Aver was deleted and only prove was there. The word prove was remaining. It means it is only sufficient to prove. No need to mention, even if the person does not mention his readiness and willingness in the plaint also, it is sufficient that if he proves his readiness and willingness, then that is more than sufficient. Okay. So, this is the second explanation. So, this is all about personal bars to relief under section 16. So, thus we have completed a small explanation regarding section 16 of Specific Relief Act of 1963. So, likewise we will be continuing with different concepts of law lectures. Please do follow this YouTube channel, which has been released very recently, which has been launched very recently. We will be coming up with many such English lectures mostly useful for South Indian students, because North Indian we already have Hindi YouTube channels, but there is lack of English YouTube channels for South Indian law students. So, keeping that thing in our mind, we have started this. So, do share it among your friends so that even they get a proper idea about this channel. Okay, so thank you all of you for watching this video, and also do not forget to like, comment, share and subscribe. Meet you in my next video. Thank you. Bye bye.